today. If you wouldn't mind standing, I've got Johnny Honnold, who's a constituent resident in my district and is a 10th grader at Pembroke Hill School. So thank you, Madam Chair.
Welcome to committee. And I also have a point of personal privilege. I have 2 pages here with me today. One is my daughter, Charlotte. If you'll stand, Charlotte, she is a junior at Blue Valley High School. And with her today is her very good friend, Sydney Huber, who is a senior at St. Thomas Aquinas High School. And also, obviously, both constituents as well. So welcome to committee, girls. Thank you for being here. Yeah. Okay, then with that, we will just want to clear up. We will try to work through until noon today, tomorrow, and Thursday so that then we can get our work done and not have to come in on Friday if at all possible. It is that time of session where we need to get bills up and out of committee if that's the will of the committee. To move them out through the process. With that, then, we will open the hearing on House Bill 2293, requiring prosecutors to disclose their intent to introduce testimony from a jailhouse witness and to forward related information to the Kansas Bureau of Investigation. And with that, then, we will ask for the bill brief from the reviser.
Thank you, Madam Chairwoman. Good morning, committee. House Bill 2293 comes to you as amended by the House Committee. That would be the House Committee on Judiciary. It also passed the House after amendments 117 to 4. And as the Chairwoman mentioned, this does deal with testimony of jailhouse witnesses in criminal prosecutions. The new section that is provided here would be part of and supplemental to our Kansas Code of Criminal Procedure. So that's the statutory area that we're in. You'll see that I've described the subsections in a little bit more detail in the bill brief, and I won't go into too much of that because I know you've got some conferees, but essentially this would require a prosecuting attorney to disclose their intent to introduce jailhouse witness testimony, provide certain information about the agreement or benefit that the witness might be receiving for that testimony, and authorize the court to make certain findings and oversee this testimony in a special way that's not maybe applicable to other witnesses. I do note that the House Committee amendments that you might be interested in were to remove a provision concerning a pretrial hearing that the bill did require as introduced, but would not require as amended. And that was just for prosecutions for murder or rape. And so that provision was taken out, but it is in the bill as introduced. And then the other provision that was in the original bill that the House Committee struck was a provision requiring a jury instruction that would be given in any case where jailhouse witness testimony was introduced. There'd be a jury instruction about that testimony, but that again has been stricken by the House Committee. If you're looking for where those are, the first one is on page 2, that stricken language from lines 10 to 30, and then on page 3, the stricken language from lines 9 to 13. Those were the House amendments to remove those 2 provisions. I'm happy to answer any questions.
Thank you. Committee, any questions for the reviser? Senator Olson.
So the testimony or the deal that's made, will the jury get a no, or is it just the court?
Madam Chairwoman and Senator, a good question. Under the bill as introduced, there would have been a jury instruction specifically saying that testimony was provided by a jailhouse witness and they would be informed of the benefit. In this case, it would be more about the cross-examination and what the jury found out through the process of the trial rather than a jury instruction. So I don't know if there's anything precluding a jury instruction if it was appropriate, but there would not be one provided in the statute. So I'll start there. And then depending on what the judge will allow, if it's a relevant question, you might be able to find out that the witness is receiving a benefit and the jury would find out that way. And if I've misspoken on any of that, I hope that some conferees will correct me. But my understanding is there are ways they could find out, but the specific jury instruction that was in here is removed. So there wouldn't be a specific jury instruction to that effect.
I would think it'd be important that the jury be able to know that. That's just me.
Committee, other questions for the reviser? Seeing none, then thank you. We will invite our first proponent conferee, Tricia Rojo Bushnell, Executive Director, Midwest Innocence Project. Please introduce yourself and welcome to committee. And you'll need to turn on the microphone. There we go. Is the blue
Thank
light
you,
on?
Madam Chair.
There we go. Thank you.
So as you heard, my name is Tricia Rojo Bushnell. I'm the Executive Director of the Midwest Innocence Project. We represent people convicted of crimes they did not commit and work to bring them home and change policies to prevent wrongful convictions in the first place. Just a brief reminder of the history of this bill. This bill was first introduced in the House in 2020. Madam Chair may remember it was heard at that time in the House Judiciary Committee. In 2021, it passed out of the House unanimously, and that was at that time. Pete Coons, a client of ours from Wyandotte County, had been exonerated in November of 2020 of a crime he did not commit in Wyandotte County. In large part, his conviction was relied on jailhouse informant testimony, testimony that had gone not fully disclosed. The deals had not been fully disclosed. The history of this informant had not been fully disclosed. And sadly, he passed away 108 days after his exoneration. And it was heard, this bill then passed the House unanimously without opposition or amendment. Last year, we were here, this committee heard this bill, but it was not worked. Pete's family at that time did testify. They were unable to be here this year, but their testimony is available in the video archives for anyone who would like to hear it. Since that time, we have worked with the Kansas County Attorneys and District Attorneys Association to make amendments to the bill, and that is what you see before you today. As you heard, it provides 3 important measures for reliability of jailhouse informants. So we know that the use of jailhouse informants is a leading cause of wrongful convictions. We can look at both the DNA exonerations and the non-DNA exonerations. We can look at cases like Pete Coons and know that those sorts of use of jailhouse informants are happening here in Kansas. And so this bill provides an ability to make the use of jailhouse informants more reliable in the testimony that comes forward. And the 3 provisions it provides, first is tracking. So if a district attorney is going to use a jailhouse informant, it will go to a centralized database where that information will be held. And the importance of that is, while the history of a jailhouse informant's use, if he's testified in another case, for example, like the jailhouse informant that was used in Pete Coons' case, the prosecutor can only disclose what they know. And so if you have someone who's a serial informant who's going around to other counties and making these kinds of deals, the prosecutor in your county may not know that information. And that's important information for them to have to assess the reliability of the own informant in front of them, and for the defense attorney to have. It's actually a required disclosure under Brady, and this is allowing the prosecutors to have that information to make that disclosure. The second piece is it has what we call an enhanced disclosure provision. So we know under the U.S. Supreme Court cases, Brady and Giglio, that this sort of information is required to be disclosed. But what we've found is that when prosecutors have to make a decision about whether or not something is exculpatory, we're all seeing the evidence through the lens in which we work, right? There's that wonderful phrase that if you're a hammer, everything you see is a nail. And so what we found is prosecutors have not disclosed this information because they did not necessarily believe it was exculpatory, even though we know from U.S. Supreme Court cases and exonerations like Pete Coons that it is. So this makes clear what that information is that they have to disclose. And finally, it provides for victim notification. So if the informant themselves is getting some sort of deal, the victim in the crime for which they were convicted is going to be notified that that's happening, because this is about reducing harm not only to the wrongfully convicted, but also to victims who are forced to relive what happened to them when a wrongful conviction is overturned. So we support this bill. We believe it would have made a vast difference in Pete Coons' case and other cases like him, and we urge the committee to pass it.
Thank you. And committee will hold questions until we hear from all the proponent conferees. Next, we will hear from Clayton Perkins, BIDS Legislative Committee. Please introduce yourself and welcome to committee.
Chair Warren and members of the committee, thank you for the opportunity to be here. I'm Clayton Perkins. I'm the Chief Attorney at the Capitol Appellate Defender Office in Topeka, Kansas, and I'm here on behalf of the BIDS Legislative Committee. I would just like to touch on a couple of aspects of this bill that I think are important, and really they're talking about making our system a little bit more transparent and making sure that information that is required by the Constitution to be disclosed under Brady and Giglio, that is exculpatory information and impeaching information, involving witnesses used by the state gets disclosed. And the thing I'd like to point out in my experience about Brady and Giglio evidence is that oftentimes, in fact, in virtually every case that I have personally seen, the prosecutor, the person, if they are aware of Brady or Giglio evidence, exculpatory evidence, they disclose that. They are not trying to hide that evidence in my experience. But what does happen in the Brady and Giglio issues that I have seen is that the evidence got missed further down the road. And that's because the way Brady and Giglio works and the constitutional duty isn't just a duty on an individual person. It's the state's duty to disclose that evidence and make sure that evidence is disclosed. The prosecutor is the person that is representing the state of Kansas and is the culmination of that process. But the exculpatory evidence that is known to other players in the system in our state government is imputed onto the prosecutor. It's their job to make sure that evidence is ultimately disclosed, but oftentimes the exculpatory evidence wasn't noted to the prosecutor to begin with. It's somewhere down the road or earlier in the process, a report that no one thought in, say, law enforcement or within, say, the jail personnel that they didn't think was important, didn't get to the prosecutor, and then didn't get disclosed. And subsection A, which is codifying these constitutional duties for disclosure, is important because everyone in the system can look at the statute and see the clear list of requirements for disclosure. It's not just about the prosecutor, but it's about the jail guards, it's about law enforcement, it's about every player in the system knowing what needs to be disclosed. And subsection B, which is then the database element, is another way of enabling that disclosure. Because as Ms. Bushnell mentioned, a lot of times these jailhouse witnesses might have been used in multiple cases, but the individual prosecutor on a case is not aware of that information. And that's why I think this is important, because it allows the state to have a way of knowing the information that they are already constitutionally required to disclose, but may not actually on an individual prosecutor level be aware of. And I am happy to answer questions at the appropriate time.
Thank you. Are there other proponent conferees in the committee meeting room? Not seeing any. We'll go ahead and then open it up for questions for our proponent conferees from the committee. Do we have any questions? And committee, please note that we do have proponent written only testimony from Michael Austin, Legislative and Coalitions Director, Americans for Prosperity, Kansas. Yes, Senator Wilborn.
Thank you, Madam Chair. I noticed the KBI is involved in this, and I'm kind of surprised they haven't stepped forward to weigh in on this. I do notice there is a representative here. If he would come forward from the KBI and give us your take on, since you're involved in this bill.
Good morning, Mr. Jacobs. Please introduce yourself and welcome to committee.
Thank you very much, Madam Chairwoman. My name is Robert Jacobs. I'm the Executive Officer of the Kansas Bureau of Investigation. I appreciate the question from Senator Wilborn. Our position on this as an agency is we believe that this is a policy decision based on this body. We did not provide testimony because we decided not to engage in this bill. As I said, we believe that this is a policy decision that the legislature should decide on. We are not in favor of this necessarily or opposed to this. So we wanted to make sure that that was clear to the committee in case there was any testimony to the contrary. And I'd be happy to answer any questions.
Madam Chair, thank you for stepping forward. It was kind of, to me, it was obvious that you were missing on this list one way or another. And so thank you for your response.
I appreciate it. We do have a fiscal impact to this. And so the fiscal impact for this bill would be approximately $182,000. We believe that that's what it will be necessary to establish a database to hold this information, as well as ongoing costs regarding the Kansas Criminal Justice Information System for each prosecutor, Those are minimal costs to the prosecutor, but we do know that there will be ongoing costs.
Is it anticipated another full-time employee is needed or
I
part-time
would
or?
have to refer back to the fiscal effect. I don't believe that there was an FTE employed in that, but I would have to go back and double check.
Thank you. Committee, questions then for our proponent conferees? Yes, Senator Baumgartner.
Thank you, Madam Chair. And it could be either conferee or both, but in opponent testimony, it stated that if this were to become law, it usurps the exclusive role of the jury as the trier of fact in determining the weight and credit of the testimony of each witness. This measure would put the court in the shoes of the jury prior to trial, holding a hearing to determine whether an incarcerated witness's testimony is reliable. Could either of you or both of you respond to that?
Please introduce yourself again. Thank you.
Hi, I'm Tricia Bushnell from the Midwest Innocence Project. I believe that opposition testimony may have referred to a reliability hearing that was amended out of this bill. So certainly, while we may have a disagreement about whether the use of reliability hearing impedes what happens with jury, it's no longer something at issue. The jury would simply get the evidence as presented through the testimony of a witness with the ability of the defense attorney to cross-examine with the information that was properly disclosed to them.
Thank you very much, Madam Chair.
I have a follow-up question. Is the Midwest Innocence Project in agreement with the two amendments made by the House Committee?
We certainly believe the bill is strong enough to stand on its own. We also would have supported the use of the jury instruction provision, but we did work very closely with the county attorneys to ensure the reliability provision was removed.
Great. So you don't have any problem with the two amendments that came out of the House Committee?
No, we support the bill as it stands.
As amended. Great. Thank you. Committee, other questions? Seeing none, then we will ask our opponent conferee, Chris McMullen, President, Kansas County and District Attorneys Association. Please introduce yourself and welcome to committee.
Thank you, Senator. Good morning. My name is Chris McMullen. I am currently the president of the Kansas County and District Attorneys Association, our statewide prosecutor association here in Kansas. I'm also the chief deputy district attorney of the Johnson County District Attorney's Office. I'm the second in command for DA Steve Howe, and I've been a Kansas prosecutor for over 31 years. And I have handled a number of what I would call informant cases, what this refers to as jailhouse witnesses case in my career. And I'm here in opposition to this bill as written. We were engaged with some negotiations with the proponents, but those negotiations did not really bear fruit. And so I want to address, if I may, some of the concerns that we have with regard to this. And I'm going to start off with my career started in the Sedgwick County District Attorney's Office, like I said, about 31 years ago. And during the course of my employment there, I was handling, as I moved along in my career, a double homicide case where the suspect in the case was in jail and was bragging about what he had done to his cellmate. And his cellmate was so disgusted with what he heard that he approached the sheriff's department and said, I need to tell somebody about what I heard. He did. And the way this works, the way it should work, the way it always works is law enforcement interviewed him. He was able to secure something in exchange for his testimony. The sands of time have kind of passed me on by with regard to what he did. That was put in writing. His statement and his agreement and his criminal history and everything were disclosed to the defense. And I know I heard a concern about how would the jury find out about it. The jury finds out about it because the defense attorney cross-examines the witness on the witness stand about their agreement with the prosecution and about their criminal history and about any inconsistencies with their statement. And this was something that happened circa 1998 or so, way back when my kids were babies. And there was a well-established body of case law back then that told us that's exactly what we have to do. And with regard to the bill that came out of the House committee, all of these provisions are things that ethical prosecutors who are following the law and following the rules have had to do for decades. And not only that, each of these provisions is covered by a statute, and those statutes have decades of Kansas and federal case law that tell us exactly what we have to do. There already exists, I know the provision in here about telling the jury about this was stricken, and that's because there already exists PIC instruction 51.100. That's pattern instructions of Kansas. And if we have an informant who testifies, the judge is required to instruct the jury that they should consider with caution the testimony of a witness who is testifying in exchange for benefits. So all of these concerns in 2293 are covered. And not only that, they've been interpreted by the laws for decades. I heard reference in the proponent's testimony to Brady and its progeny. Brady is a Supreme Court case that requires the prosecution to turn over exculpatory information to the defense. And that's what we do. Just last week, I taught at the KCDA Trial Advocacy School, and my subject was ethics. And the rules of ethics that cover lawyers have a special rule for prosecutors that's called Rule 3.8, Special Responsibilities of a Prosecutor. The notes to that say that a prosecutor has a duty to justice that is greater than its duty to the state. We're considered to be ministers of justice. And Rule 3.8, as I taught our young prosecutors at this school, is vastly broader than discovery rules or Brady, and it imposes an absolute responsibility for us to turn over this material. I never want to see ever somebody who is not guilty or who is innocent convicted. My job is to seek justice on behalf of victims, on behalf of our community, on behalf of my profession. And anytime, and what I teach is anytime I see something come across my desk that I roll my eyes and I say, oh my goodness, that's my first cue that I need to turn it over. So if a informant comes forward with information, most of the time it's because they're completely disgusted by what their cellmate is telling them, and we execute agreements with them, we turn those over. And our concern about this is this creates new language for the courts to interpret when we already have an established body of case law. With regard to the database, and I'll be brief on that, one of the negotiations that we had with the proponents of this was establishing some sort of our database. It actually kind of makes sense that if this is going on statewide, that we have a tool for this. My concern about this is that people on that database are labeled as informants. And if that information is available to the public, because I believe there's a sunset provision in there for the Open Records Act, my concern is that they would be labeled within the system in public as snitches. And informants are not looked upon favorably within our judicial system, even though they oftentimes come forward and provide valuable, truthful information that's subject to cross-examination. They're not looked upon very favorably, and I wouldn't want harm to come on them by disclosure any more than I would want harm to come on anybody in our system. So we are in opposition. We are willing to talk to the proponents about that provision, about a bill coming out of committee that would have some sort of provision. But our position is that the A, B, C, D, and so forth are just redundant and would actually insert confusion into our judicial system when there's already established rules.
Thank you. Committee, we do also have opponent written only testimony from Mark Bennett, Sedgwick County District Attorney. And if there are no other opponent conferees, we will go ahead and open it up for questions for Mr. McMullen. Senator Wilborn.
Thank you, Madam Chair. Thank you for being here. I didn't do my research. Did you testify on the House side on this bill?
I did.
And at that time, you just were not able to get together with the proponents.
I believe that negotiations kind of fell through. I'll just leave it at that.
Senator Baumgardner.
Thank you, Madam Chair, and thank you, Mr. McMullen, for being here. I'm looking at your testimony. It's dated today.
Correct.
So when I look at it, and bullet point number 4 is essentially we're striking it because that's not a part of the amended bill.
That's correct.
You made mention of database in your oral testimony, but I don't see any mention of those concerns in your written testimony. So I guess I'm curious of the 6 bullet points. We pulled out one because it's no longer relevant. Are there other bullet points that should be pulled out? And I'm curious why your concerns about the database aren't in your testimony. Thank you, Madam Chair.
I guess my answer to the second portion of your question is that I have had an opportunity to think on this, and I'm bringing my concerns before this committee because that's where it is, and that was my concern. I did testify with regard to the database in person in front of the House committee as well. And with regard to the bullet points, they're still stricken, and I just wanted to make sure that this committee understands that we have concerns even about the original bill as well, and those points in the unlikely event that those would get brought up again.
Senator Corson.
Thank you, Madam Chair. I think I'm struggling with your opposition to this bill for a couple reasons. The first is because essentially what I understand your testimony to be is that you're already doing many of the things that are required under this bill. This is already your practice. So I know that you're going to say, well, there's a set body of case law under that undergirds that, but I'm struggling to see the harm in just codifying what you're stating to the committee is already your existing practice. And then my second question would be, if we struck the sunset provision regarding the database, would you support that? And would that make you more inclined to be more supportive of the overall legislation if we struck that sunset? Thank you.
With regard to the overall legislation, no. With regard to perhaps legislation that included a database, yes, if that makes sense. In other words, I'm not prepared to concede the rest of them. And with regard to that, my point is that those provisions are already codified. The discovery statute already requires us to do those things. Brady already requires us to do those things. Rule 3.8 already requires us to do those things. And so anytime you recodify something, we have a established body of case law that tells us how to interpret and how we're supposed to act under the discovery statute. If we enhance that, that creates some uncertainty because then a different panel of the Court of Appeals or a different version of the Kansas Supreme Court could interpret it differently. We know what we're required to do based on existing Kansas case law and rules.
Is there concern that if the bill becomes law and it's codified in statute, that would be more avenues for appeal?
Well, it would be because it's a brand new area of law. It's different words. It's a different way of phrasing the same thing. And, you know, the appellate courts presume that the legislature did things on purpose and are directing us to do things differently. And so, yes, my concern is, first of all, that it's unnecessary, and second of all, that it creates uncertainty in the appellate system.
Thank you. And the reviser wanted to clear up a few points about the open records aspect.
Thank you, Madam Chairwoman. Jason Thompson, Revisor's Office again. I just wanted to be clear that the 45229 provision that would allow this or would require this provision to expire unless renewed by the legislature is added by our office. That's our statutory duty under KSA 45-229 to make clear that all open records exceptions have to be reviewed unless they meet an exception. It's not necessarily clear that one of the exceptions applies here. So even if we didn't say it expires in 5 years, I think under 45229, our office would flag that as one you're supposed to review. Once you've reviewed it, then you can continue it in perpetuity. In fact, you'll have the bill to do that for sections enacted 5 years ago here later this week in our annual open records review bill. But that's a statutory process that we feel has to be in there unless one of the exceptions is met. So I'll dig into that a little further to see if it could be removed in this case. But our initial reaction was it could not. You would have to review this in 5 years.
I'm looking at some of the written testimony from Mark Bennett, District Attorney for Sedgwick County, or I guess for the 18th Judicial District. One of his points about the database is that witnesses of all kinds make requests before testifying. Whether we, the prosecution, agree to those requests or how we negotiate those conversations can vary widely. This bill would seem to require the state to chronicle the details and potential back and forth of every requested benefit, including those denied and including those from, quote, intended, close quote, witnesses who never actually testify. This is unduly onerous and far exceeds the tenets of the Brady and Giglio cases or even common sense. Could you comment on that?
I would agree with that. I actually had an opportunity to discuss this with Mr. Bennett last week because he was a faculty member at the same school that I was a faculty member of that. And I guess that's a perfect illustration of what I'm talking about, that it changes the existing case law, that we know what. And I think he points out that lots of people come and say, hey, can I do this? This is what I want. And many times we say no. And my concern is, again, that we'd be required, and I'll echo what Mr. Bennett said, that every time somebody asks for something, even if that doesn't come to fruition, does that mean they go on the database? Does that mean we have to report it? And so forth. And so our practice in Johnson County is to turn everything over, but there's a lot of instances where there's just a lot of noise out there that never results in testimony.
Another comment that he had in his written testimony regarding the database is that under no circumstances should a list of people who have, quote, snitched, close quotes, be compiled with any intention that it could someday be readily available to the public through a KORA request or some other routine process, particularly if the bill continues to include, quote, intended, close quote, witnesses who never actually testify publicly. Is that a concern you share?
And that's exactly what I was talking about, was that in the jail system, in the prison system, in the judicial system, people who are oftentimes labeled snitches, who are simply coming forward and testifying with regard to what somebody else said. In other words, they can oftentimes be helpful. And it is, I think the title of this bill, Jailhouse Witnesses, is a little bit pejorative, and they're informants, certainly, but they are certainly looked forward to negatively within our system. And my concern would be getting that list could put those folks in danger as well.
I do also have a question regarding Section C of the bill on page 3, regarding the requirement of the prosecutor to notify any victim connected to the criminal prosecution. Is that?
We're already required to do victim notification. The legislature has given us the Kansas Victims Bill of Rights. And again, if a prosecutor is doing what they're supposed to do under the law and the Constitution, they're letting folks know. That typically doesn't get down into the weeds with regard to what we tell folks, but victim notification is already required.
Is there any confusion about line 8 on page 3, that the prosecuting attorney shall notify any victim connected to the criminal prosecution? Is it the criminal prosecution of the jailhouse witness, or is it the criminal prosecution of what the witness is testifying about the other defendant?
I think that's an outstanding question. And I think Mr. Bennett raises that in his proponent testimony as well. And again, is another example about somebody has to interpret that. That's the courts. And so our concern with regard to that would be that it is a little bit confusing, and which victim do we have to inform on? If you have somebody who's in jail serving a sentence, do we have to let their, the example I use, somebody who's a thief and he's in jail with a murder, do we have to let the merchant who he stole from know that he's going to testify, or is it the victims of the homicide that we have to let know? And when? Oftentimes our victims are also witnesses in the case, and we typically don't talk about the facts of the case with our witnesses until they're done testifying so that their testimony isn't tainted. So I'd be a little bit concerned with regard to something that specific when, again, we're already required by law to keep our victims posted about what's going on.
And currently, when is that notification required to be given to the victims in current law?
It kind of depends. We reach out to our victims immediately and get them into the fold immediately. We've got resources, I think, that other jurisdictions don't, but I know that almost every jurisdiction has somebody whose job it is to reach out to the victims. We sit down with our victims and talk to them about plea negotiations, which we talk to them about the strengths and weaknesses of our cases. And of course, if they're testifying, we sit down with them at length to prepare them for their testimony. So it is an ongoing process, and we're required to talk to them about plea negotiations, but we start at the beginning and end at sentencing and beyond sometimes.
Thank you. And one last question from me anyway, regarding appeals, that if this is codified rather than case law as prosecutors currently operate under, as well as rules of professional conduct and things, that it would open the door to new avenues of appeal for overturning what would otherwise be a conviction that wouldn't have these same avenues of appeal, because the court would be asked to, on appeal, interpret this new statute. Do I kind of have the concern stated correctly?
Because we didn't do what this word said, it's something else to appeal. In other words, right now we know what we have to do, but and I think Mr. Bennett talks about, I think, proposed witnesses. Okay. Okay, so we don't turn over somebody who says, "Hey, I've got information," and we just don't follow that through or something like that. Yes, the answer is yes. It is anytime you put new words in there, those new words are subject to interpretation. And the Kansas has a very good appellate defender system. They would jump on those words and take them on up.
Thank you. Committee, any other questions? Senator Baumgardner and then Senator Corson.
Thank you, Madam Chair. Very little time has been spent talking about victims. And there is a component in here. In fact, the chair mentioned line 8 of page 3. I'm a little bit more interested in lines 6 and 7. It says, if a jailhouse witness receives any benefit in connection with offering or providing testimony against a defendant, the prosecuting attorney shall notify any victim connected with the criminal prosecution. But again, it's receives any benefit. And I'm not sensing from what you shared that the practice is very uniform throughout the state with regard to victim notification. And specifically what's in here is notifying victims if a jailhouse witness received a benefit in connection with offering or providing testimony. So you indicated you made reference to Attorney General or to District Attorney Bennett's comments, but have you or others worked to come up with language? You indicated that it was confusing. So have you come up with language that would eliminate the confusion?
I'm not really sure, quite frankly, to what end we would do this or when we would do this or what the consequences for doing it or not doing it are.
I think I'm more interested in making sure that it's done, that witnesses are informed. So you used the example of a merchant who had something stolen and that same individual committed a murder. So are we to address the
I
victim?
understand what you're saying. So the answer would be that, okay, so if you have a situation where you have two individuals in a jail cell, okay, they both got pending cases, and we make a deal for the thief to testify against the murderer, we would certainly let the thief's victim know this is what we're doing. We are going to allow him to plead guilty to an attempt in exchange for his testimony against the murderer. That's something I believe we're required to do now, because that would be part of his plea negotiations. I believe the Kansas Victims' Rights Act requires us to do that now, to let those folks know what's going on, and that would certainly be our practice in that case. So thank you for that opportunity to clarify that.
Okay, and I guess, Madam Chair, I'm not clear that because of what you had said prior to in answering this, I'm not certain that that's being applied consistently throughout the state.
I don't know. Obviously, we've got, 105 different counties, and I don't know what goes on in each of those jurisdictions. What I can tell you is what we teach our prosecutors. And again, I've been teaching at KCDAA for 25 years or so, and what we teach is disclosure and victim notification. That's what we teach.
So again, Madam Chair, is there some language that you could give? And I think the language is more specific to line 8, so that we have that clarity, so that everyone knows regard. Thank you, Madam Chair.
Thank you, Senator Corson.
So thank you, Madam Chair. So to follow up a little bit on what Senator Baumgartner just talked about, my concern is that it seems like obviously this isn't being followed in every case, because we have the example of Pete Coons. And so if this was already happening in every case across the state of Kansas, if this was already existing practice, we wouldn't have had somebody like Mr. Coons, who spent 12 years in jail, who was wrongly convicted based on jailhouse informant witness. And if that's one high profile case that we know about, I think we can reasonably suspect that there are probably, I don't want to say many, but there are probably other folks who are now sitting in jail in Kansas who were convicted wrongly because of jailhouse informants. And in Missouri, the Kansas City Star reported that it's happened at least 10 times in Missouri in recent years. This Kansas City Star article also references a recent study by the University of Notre Dame that uncovered more than 200 such wrongful convictions across the country. So we know these jailhouse informants are effective in persuading jurors. We know that they have problems with their reliability. And your testimony is basically, legislature, you don't need to worry about this because we're already doing all the things that are required under the statute. But if that was true, we wouldn't have the case of Pete Coons. How do we explain that?
I would say, and I hesitate to talk about Mr. Coons' case because I'm unfamiliar with all the facts.
Right, but that was a
about that
Kansas
case.
case,
But if we,
where those prosecutors arguably underwent
go
the same
ahead and
training,
answer.
arguably had the same obligations that you're speaking about, and somehow the ball got dropped and that was not disclosed.
and I would say that is on that person for not following the law. In other words, if they were willing to violate the laws that are already on the books, who's to say they wouldn't violate the new set of laws that's on the books? In other words, at the time, whoever that prosecutor was, if that's exactly what happened, they made a decision not to follow laws that were already well established, that were already very clear, that already instructed them on what they're supposed to do. Like, as I pointed out, in 1998, I knew what I had to do, okay? And just like any other law, we can, our theft laws don't prevent people from committing theft because people willfully violate the law. And I don't know if that's what
We
happened.
still make laws against that.
Right. And
we still have laws against
we
that.
do. And we have laws against what happened there. And I know we're not talking about criminal responsibility. We're just talking about, my point is, those laws are already on the books that already instruct prosecutors on what they're supposed to do. They are crystal clear. And if somebody, it's terrible if somebody willfully violates the laws. And I would never want that to happen. But unless somebody willfully violates the laws, they're going to be turning this stuff over to the defense.
Thank you. Committee, any other questions? Not seeing any, then thank you very much for your testimony. I will ask, are there any neutral conferees in the committee meeting room or on WebEx? Seeing none, then want to thank all of our conferees today for your testimony and for appearing in committee today. Appreciate that, as well as the written testimony, and perhaps the proponents and the opponents can continue conversation about the bill. With that, then we will close the hearing on House Bill 2293 and open the hearing on House Bill 2326, extending the sunset date on the Scrap Metal Theft Reduction Act and clarifying that catalytic converters are covered by the act. With that, a brief from the reviser.
Thank you again, Madam Chairwoman. Jason Thompson, Revisor's Office. House Bill 2326, as amended by House Committee, comes to you via the House Judiciary Committee, and it did pass the House 120 to 1. As many of you know who've been around here for a while, we have a Scrap Metal Theft Reduction Act. The statutory history of it indicates we had a few of those sections as far back as 2007. Of course, significant amendments made in 2015, and then again in 2019, including one of the provisions in this bill that was enacted in 2019, the sunset provision that I'll talk about in just a second. Section 1 is the definition section for the Scrap Metal Theft Reduction Act, and the substantive amendment here is to clarify that the term regulated scrap metal includes catalytic converters, and then also to add a definition of catalytic converter there at the end of the definition. That amendment of the definition of catalytic converters that's in bold italic was added by the House Committee. That was the amendment that they made. Section 2 then amends the sunset provision that I referenced a moment ago, again enacted in 2019 by the legislature, that just said the provisions of this act would expire on July 1st of 2023, essentially requiring you to come back and review the act, which is what's now brought before you, if you wish to extend that sunset to July 1 of 2028 as proposed in the bill. Be happy to answer any questions.
Thank you. Committee, any questions for the reviser? Seeing none, then we will ask proponent Robert Jacobs, Executive Officer with the Kansas Bureau of Investigation. Glad to see you're still here in committee, and please go ahead and introduce yourself.
Now? Yep. Thank you very much, Chairperson Warren and members of the committee. My name is Robert Jacobs. I'm the Executive Officer for the Kansas Bureau of Investigation. We stand here in support of House Bill 2326. We believe that the extension of the sunset for the Scrap Metal Theft Reduction Act is important. Over the past several years, we've heard multiple local law enforcement agencies calling the KBI and requesting information about the scrap metal repository that we created. We began collecting information in 2020, and since then we have collected information on 9.6 million pieces of scrap that have been sold in Kansas. That repository was created to provide a tool for law enforcement when it came to the theft of scrap metal in Kansas. This year alone, in fiscal year 2023, law enforcement has called and queried that database approximately 1,567 times. We do believe that adding the addition of the definition for catalytic converter will help with clarifying in the statute what is required to be provided to the KBI in the repository, and add that catalytic converter piece. That is an area of theft that we've seen a remarkable increase in across the state. And then finally, as I said before, we do believe that by extending the sunset on this provision in this statute, that it will continue to give law enforcement the tool to use the repository to reduce theft of scrap metal and specifically catalytic converters in their community. And with that, I'd be happy to stand for questions.
Thank you. We'll go ahead and hear from all the proponents, and then ask our questions.
Thank you.
With that, then, we will hear from Detective Fusel, Wichita Police Department via WebEx. Please introduce yourself and welcome to committee.
Thank you, Madam Chair and committee members. I'm Detective Dustin Fussell with the Wichita Police Department, speaking on the behalf of the City of Wichita. I'm here today to provide testimony on the passage of House Bill 2326, which further defines catalytic converters and extends the sunset of the Scrap Metal Theft Reduction Act. We're also requesting an amendments to KSA 50-6-111 subsection D by adding provisions 22 and 23 to it. And we'll go over those here quickly. Currently, my assignment is with the property crime section, where I've had the opportunity to investigate property thefts involving catalytic converters and other scrap regulated materials. I've seen firsthand the impact that catalytic converter theft has had on businesses who have been repeatedly targeted and individuals who are unable to repair their vehicles due to financial hardship. In some cases, repairing a vehicle can actually cost thousands of dollars. Looking back at the past several years, Wichita has seen thefts of catalytic converters on the rise, and that's a nationwide thing. To give you some examples, in 2020, we saw a total of 541 reports of catalytic converter theft. In 2022, we had 1,123 reports of converter theft. It doubled. So you may be asking what's causing this increase. Well, for one is the precious metals. Supply and demand issues due to COVID closures caused these metals to rise dramatically. To give you an example, rhodium, which is one of those metals, rose to $29,000 per ounce in 2021. And in 2019, comparatively, rhodium was only $5,000 per ounce. Another reason is there's a low risk with a high reward to converters. These things are easy to steal. It's quick. I've seen people on videos remove these things in 60 seconds. It's also a very target-rich environment. Anywhere that you look, you're going to see vehicles. And if there's a certain vehicle that you want to target, you can find it. Solvability of these cases can be very difficult as there's really no unique markings on these converters. Most converters can actually even fit a series of different makes and models of vehicles. And lastly, it's very lucrative. Depending on the type of converter and the material content, a seller to a scrapyard can make anywhere from $100 to $1,000 per converter on average. I actually saw a ticket, individual sold 4 converters to a local scrapyard here in Wichita and made $1,600 cash. We know that even certain individuals here in Wichita are making millions of dollars on converters. So how do we reduce it? Well, in the fall of 2022, the city of Wichita actually recognized the need to combat this epidemic and implemented law to reduce catalytic converter theft. This law made it illegal to possess catalytic converters here in Wichita if you didn't meet certain exceptions of the ordinance. And I believe Topeka actually just passed this as well. And so far, we've seen actually some promising results. Another way that we've worked to decrease catalytic converter theft is through police investigations. I personally, on numerous occasions, have used the requirements of the Scrap Metal Theft Reduction Act and the K-Scrap database to investigate these cases. To give you an example, I was assigned 2 cases with a suspect vehicle and a tag that was involved in catalytic converter theft. There was no suspect really that we were able to identify, and the owner of that vehicle was deceased. We didn't have anything else besides that information. Luckily, we were able to use the K-Scrap database and search this vehicle and generate a lead on 2 suspects. We found that during a 1-month time period, 2 individuals sold 40 converters to a local scrapyard here in Wichita and made $13,355 profit. These suspects were ultimately interviewed and we were able to charge them with felonious charges through the Sedgwick County District Attorney's Office. This case portrays why it's important that all scrapyards report transactions involving catalytic converters. By amending 2326 to define and include catalytic converters, we can assure that law enforcement in Kansas have a better ability to investigate these cases. We're also in support of 2 additional amendments, like I said, to KSA 50-6-111 subsection D to help reduce catalytic converter theft in Kansas. So 22, it states any catalytic converter that has a defaced identification mark, owner applied paint, or other identification numbers, or which has been intentionally altered by removing or obliterating the make, model, or manufacturer's number should not be accepted. And this goes back to converters. They're not specially marked, which makes them much less likely to be identified as stolen property when we encounter them. This attracts bad actors due to the low risk and the high reward of this particular crime. We want to be able to give Kansas citizens a cheap and simple solution to safeguard their property. Ones that have called me multiple times, that have been victims multiple times, have said, what can we do? What do we need to do to help safeguard our property in the future? And one thing that I suggested to them was use a high temp spray paint and spray your converter. They're $5-6 at AutoZone, and it's a cheaper alternative to putting a rebar cage on a converter, which costs like $500. So we've seen some success in this by communicating this with our scrapyard, saying, hey, please don't take converters that are spray painted. And actually I've had a scrapyard reach out to me and said, hey, some people brought in some converters that were spray painted. We turned them down. Here's their information, which helped generate a lead for us. Also, in some cases, this also helps law enforcement an easier ability to identify ownership of these converters when we encounter them in the street or find somebody in possession of them. Next is 23, is any byproduct or dust containing regulated scrap materials as defined in KSA 50-6, 109 subsection B2J, B2K, and B2L. And what those are in the subsections is the 3 particular metals that are in catalytic converters: rhodium, platinum, and palladium. This essentially what is called on the street is catalytic converter dust. What people are doing now that we're finding is inside a catalytic converter, there is a honeycomb of this particular metal material. And people are extracting this material by crushing the converters, either by a primitive method of like using a pole and busting it out, or using some type of hydraulic press. They're collecting this material and they're just bringing in that dust to some scrapyards, especially here in Wichita. And then they end up getting actually more money for this because scrapyards don't have to pay their distributor who processes that material to remove or decan these converters to get that material out. The only reasons that we can think of why these people are bringing this material in is 1, yes, it does pay more money, but 2, it also conceals the potential evidence of theft. We know as if we're in law enforcement and we have like a hit for a suspect, like in the prior case that I was telling you about, of somebody bringing in converter dust and I had like their tag, for example, I wouldn't be able to determine whether or not that converter came off of my victim's vehicle or if it was a mixture of 5 or 6 different vehicles. It sort of kills any type of investigation that we have if we don't have this passed. So because of that, the Wichita Police Department does support House Bill 2326. We ask the committee to recommend this bill favorably for passage. Thank you for your time and consideration.
Thank you. Appreciate that. Next, we will hear from Ed Klump, Legislative Liaison with the Kansas Association of Chiefs of Police, Kansas Sheriff's Association, and Peace Officers Association. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. My name is Ed Klump, and I'm here on behalf of the Kansas Sheriff's Association, Kansas Association of Chiefs of Police, Kansas Peace Officers Association. It's our pleasure to speak in support of this bill. A lot of what is in my testimony has already been covered. I'm not going to repeat that, but there's a couple of things I'd just like to add. We requested this bill primarily to extend the sunset so we don't lose this great investigative tool. The secondary reason is all the catalytic converter issues that's been talked about, and that's also a very important issue. I do want to add the use of the database that's at the KBI. In 2020, July 2020 is when that was finally put into place, and we were able to start using it. And during 2022, there was 4,757 inquiries into that data, and that was a 400% increase over 2021. And so it's getting used more widely all the time. There's now 165, well, that was as of a couple of months ago, there was 165 investigators across the state that are using that database. You heard from Wichita PD about their amendment. They would like to add to this, adding further clarification on the catalytic converters. We're in full support of that amendment. We worked with them in developing that, and we would appreciate it if that amendment could be made. Bottom line is we don't want to lose this valuable investigative tool, and without action by the legislature, it will go away July 1st, 2023. And I'll stand for questions when it's appropriate.
Thank you. Committee, also want to direct your attention to proponent written only testimony from Don McNeely, Kansas Automobile Dealers Association, Shahira Stafford, Kansas Cooperative Council, Randy Stuckey, Kansas Grain and Feed Association, Renew Kansas Biofuels Association, and Kansas Agribusiness Retailers Association, as well as from Michael Ruffin, Regional VP of External and Legislative Affairs, AT&T Kansas. With that, then, we will open it up for questions for any of our proponent conferees. Seeing none, then want to also ask, are there any neutral or opponent conferees in the committee meeting room or on WebEx? Seeing none, then want to thank everyone for their very thorough testimony and for appearing in committee today. And we will then close the hearing on House Bill 2326. Committee, we do have a couple of bills to work. We're trying to work our bills Tuesday, Wednesday, and Thursday so that we don't need to meet on Friday. So if you'll stand at ease just a minute and I will pull those up. Thank you. Thank you, committee. We will turn our attention to House Bill 2015. It's a bill we heard some time ago relating to infectious disease and authorizing the designee of an employing agency or entity to petition the court for an order requiring infectious disease testing. With that, could we have a bill brief from the reviser on House Bill 2015?
Thank you, Madam Chairwoman. Jason Thompson, Revisor's Office. As you mentioned, this is about the designee of an employing agency or entity petitioning the court for the order requiring infectious disease testing. Under current law, this already happens, but it is limited to the agency head that can make that request. So the proposal is just to add the agency or entity head's designee to the people who can make that request.
Thank you. Thank you, committee. Are there any questions for the reviser? Seeing none, then I do have a proposed amendment to House Bill 2015, if the reviser will pass that out. And it is simply to change on page 2 of the bill, the enactment date in section 3 to the Kansas Register so that we can get this to conference committee. And I will move that we amend House Bill 2015 with the amendment changing the enactment date. Is there a second? Senator Wilborn, thank you. Committee, you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. We are back on the bill. What's the will of the committee for the bill as amended? Senator Wilborn.
Thank you, Madam Chair. I recommend that we move House Bill 2015 as amended out favorable for passage.
Thank you. Is there a second? I'll go ahead and second. You all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Next, we will take a look at House Bill 2065, an act concerning family law relating to dissolution of marriage, allowing change to name other than former or maiden name. And with that, then, a brief from the reviser.
Thank you again, Madam Chairwoman. Jason Thompson, Revisor's Office. This is the bill that allows, so under current law, the spouse can change their name to their maiden or former name. Otherwise, you have to go to the other name change statutes and follow those procedures. This would open it up so that the spouse can change their name to a former name or can ask the court to change it to a name that is different than such spouse's former name. So you'd be able to seek any name that the court would approve.
Thank you. And just for a point of clarification on House Bill 2015, we did properly move the amendment, and then we did properly move the bill as amended. Is that correct? Okay, great. Just wanted to make sure procedurally we were advancing the bill as intended by the committee. Committee, I do have a proposed amendment on House Bill 2065. It is again in Section 3 to change the enactment date to the Kansas Register. And I will go ahead and move the amendment. Is there a second? Senator Bowers. Committee, you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. We are back on the bill. Is there a motion to move the bill as amended favorably for passage? We have the motion from Senator Olson and a second from Senator Gossage. As amended, as we said, exactly. Committee, you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Committee, we will next turn our attention to House Bill 2131. We heard that Monday this week, which I guess was yesterday. And it is concerning the Kansas Judicial Council relating to duties and mission. And with that, a brief from the revisor. I think I've basically said what we need to, but go ahead.
Thank you, Madam Chairwoman. Jason Thompson again with the revisor. And yeah, that's pretty much it. This changes the brief statement of the Judicial Council's mission in KSA 20-2203 and changes it to a new mission that they've requested you to enact.
Committee, any questions for the revisor? Seeing none, then I have a proposed amendment to House Bill 2131, and it is again in Section 3 to change the enactment date to the Kansas Register. And I will go ahead and make the motion on the amendment. Is there a second? Senator Gossage, thank you. Committee, you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. We are back on the bill. Is there a motion regarding the bill as amended? Senator Gossage.
So moved.
Is there a second? Senator Stephan. Committee, you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. And finally, for today, we will take a look at House Bill 2214. 2214 concerns the Department of Corrections relating to facilities and changing the name of the Larned Correctional Mental Health Facility to the Larned State Correctional Facility. And with that, a brief from the revisor, please.
Thank you again, Madam Chairwoman. Jason Thompson, Revisor's Office, and this is the bill that amends the definition of correctional institution in one statute, and it calls the Larned facility what the Department of Corrections is currently calling that facility, and also strikes a couple of facilities that are no longer in operation from the definition.
Thank you. Committee, any questions? Not seeing any, then I have a proposed amendment. It's kind of a theme today to change the enactment date to the Kansas Register. And I will go ahead and make the motion on the amendment. Is there a second? Senator Bowers, thank you. You all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Yeah, you want to have your no vote recorded, Senator? Committee, we are back on the bill as amended. Is there a motion to move the bill out of committee favorably as amended? Motion from Senator Olson. Is there a second? Senator Gossage. You all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Committee, thank you very much for your attention. Those are the 4 bills I intended to work today. There will be others that we will intend to work tomorrow so we can get our work wrapped up by the time we leave on Thursday. With that, committee, thank you, committee, for your attendance, for your attention, for those in the committee meeting room, our conferees, as well as those conferees on WebEx and those following along online, and to our staff. Thank you very much. We are adjourned.